Counsel on behalf of the appellant may proceed.
Good afternoon. May it please the court, my name is Sharon Proctor. I represent the appellant, Kathryn Bowe. I would like to reserve 5 minutes for my rebuttal, please. This appeal arises from a workers' compensation case in which the JCC entered an abbreviated final order apportioning 30% of the claimant's permanent disability to a prior accident. Unfortunately, Ms. Bowe's trial counsel did not become aware of that order for 13 days because the order got misdirected within his office by his staff. When he did learn of the order, he filed a motion to vacate that abbreviated order and requested that the JCC enter a full order with findings of fact and conclusions of law that would be appealable to this court. The JCC denied that because his motion was filed 4 days beyond the 10-day window that's provided in the Administrative Code Rule 6.119. The JCC's denial of that motion to vacate was reversible error for several reasons. First, the JCC should have added an additional 5 days.
Let me ask you a more fundamental question then. What is you're appealing the order denying the motion to vacate?
That's correct, Your Honor.
Is that an appealable order? What is the authority for appealing that order?
It's a final order that's directly appealable to this court as being a final order in a workers' compensation case.
Well, the way I read Rule 9180, that is an order. It's really just what it refers to in there is a request, and not a motion to vacate, a request for findings, which is a prerequisite to appealing an order, an abbreviated final order.
So would it be Your Honor's position that there's simply no appeal that can be taken in this case whatsoever?
Well, that's not my position. I don't have a position.
Okay.
I want to hear the argument.
Well,
I'm asking you because I'm concerned about whether this is an appealable order.
Well,
it strikes me as if it's really just like a rehearing, which was late, and you couldn't appeal the final order because the rehearing was late, didn't suspend rendition, and so you go back and you say, okay, I'll appeal the order denying rehearing.
it's not like that, respectfully, Your Honor, because in this case, there was a final order. It was an abbreviated order. There was a notice of appeal filed from that final abbreviated order before the end of the 30-day period, which is the appealable time.
However, that appeal was dismissed.
However, that appeal was dismissed. Before that appeal was filed, the judge heard this motion to vacate and entered a final order denying the motion to vacate. So that order denying the motion to vacate then became the final order with nothing left to do in the trial court.
In other words, if somebody messes up on an abbreviated final order, all you have to do is subsequently file a motion to vacate, and you can then transform an unappealable order into an appealable order?
Respectfully, no, Your Honor, because the order that's appealable is not that abbreviated final order. This court has previously dismissed that appeal.
No, you're saying that you're appealing the motion to vacate.
We're appealing the order denying the motion to vacate as an abuse of discretion. If that were not true, then the constitutional right to an appeal has been completely denied, because you're essentially then saying that neither the original order, the abbreviated final order, nor...
How do you figure that? If you had filed a timely request for findings, the order would have been appealed.
Because a 10-day window of time, Your Honor, is not a reasonable restriction upon the right to appeal, particularly if that 10-day window does not provide for any additional time after service by mail. So it's so restrictive that it thwarts.
10 days to appeal is just 10 days to ask for written findings.
It's 10 days within which to preserve the right to appeal, or that right is forever barred. And that 10 days includes the time that it took for the JCC's order to travel to counsel's office, which was 4 days, as the record shows, so that we have an administrative rule that, one, violates a statute, which says that order does not become final for 30 days, not 10 days. And second, we have an administrative rule that is so time restrictive that it's thwarting legitimate appellate rights, which the Florida Supreme Court has said the legislature may not do. Certainly, if the legislature cannot do that, then the Division of Administrative Hearings could not do that. I beg your pardon?
10 days to file a motion for rehearing in a civil case.
That's correct, but you still have, I'm sorry.
I was going to say, if you file one late, then it doesn't suspend the date of rendition.
That's very true. And litigants, slip over that. It's not uncommon for this court to dismiss things because it was not timely filed. However, in a civil case, Your Honor, if that motion for rehearing were late, we're beyond that 10-day window, then there's still a full 30 days within which to appeal the original order. The right to appeal the order on the merits has not been lost by the failure to get a timely motion for rehearing in within 10 days. So that's the distinction between what would happen in a civil case and what has happened here under these new rules that have been promulgated by the Division of Administrative Hearings.
Tell me, in our order of dismissal of the appeal from the abbreviated order, we noted that the issue regarding the timeliness of Bowe's motion to vacate could be raised in the related appeal, which was then pending.
Yes, Your Honor.
Was there anything in that order indicating that this court would accept jurisdiction over the related appeal?
Yes, Your Honor, because there was a challenge to jurisdiction actually by this court. There was an order to show cause issued by this court in this related appeal.
So what happened actually is that you had an abbreviated order. You had an untimely filed motion to vacate. However, you nevertheless, if you look simply at the 30-day appeal period allowed by the rules of appellate procedure, general appellate rules of procedure, you did have a notice of appeal that was filed within 30 days from the date of the entry of the abbreviated order.
That's correct, Your Honor.
Okay.
And Your Honor has said that the motion was untimely, the motion to vacate. It's our position here that, in fact, the motion was timely. The JCC erred by treating it as untimely. And there are two reasons for that, Your Honor. I'd like
so
to...
what we're concerned about today is not the timeliness of the notice of appeal.
Okay.
Necessarily, as governed by the general rules of appellate procedure. But we're concerned about simply the timeliness of the motion to vacate.
All right, and if I may address that, Your Honor, that motion to vacate should have been treated as timely by the JCC for two reasons. The first reason is that rule, that administrative rule that says 10 days, is permissive by its plain terms. It says may file within 10 days. It does not say within 10 days only. And certainly there have been rules promulgated by the Florida Supreme Court that use that language.
If that's the case, why was it necessary for this court to dismiss the prior appeal?
The prior appeal, Your Honor, was dismissed pursuant to a different rule, a rule of appellate procedure, Rule 9.180B2, which provides that essentially that abbreviated final orders cannot be appealed, that they've been waived, that the proper procedure is to have the judge of
if the request is not timely filed.
That's correct, Your Honor.
Well,
but
how do you separate the two, though? Either the motion to vacate or this particular rule of procedure.
In all due respect, Your Honor, I believe the dismissal of the prior appeal was not well taken, because in fact that order was timely filed below. However, this court
we're not without power to revisit the
okay.
prior orders.
Okay. Well, then I would suggest that, respectfully, that this court should revisit that and look at that, because since Bowe's motion was in fact timely, both because it's an advisory rule, it's not a mandatory rule, and there's precedent from the Puckett oil case.
Don't you think it says may in there only to signify that you're not required to file one of those? In many cases, you might just accept an abbreviated final order.
If that
especially in light of 9.180B2, which says unless a request for findings of fact and conclusions of law is timely filed, review by appeal of an abbreviated final order shall be deemed waived. They have to be read in paramateria, don't you think?
Yes, they do, Your Honor. And in fact, when they are read in paramateria, that's what creates this constitutional problem that we're running into, with the time being so short that the right to appellate review is cut off, perhaps before the trial attorney is even aware that the order's been entered.
It's not a time to appeal. I see your point about rehearing. It is different. I think you make a good point on that. But it's not really a time to appeal. It's a time to preserve the right to appeal. Would you agree with that?
It is a time to preserve the right to appeal, which is unconstitutionally short in this case.
Let me ask you one other thing about 9180. It says in the second sentence of the rule on B2, the filing of a timely request, they call it a request, you're calling it a motion to vacate. I think the JCC rules call it a motion to vacate. The filing of a timely request tolls the time with which an abbreviated final order becomes final for appeal. So let's say if you had filed a timely request on the 9th day, let's say, you'd have 30 days from the denial of your motion to vacate to file the appeal, because it tolls the time for an appeal. But then if you go over to Rule 9130, sub 4 says that any order entered on a motion that suspends rendition of an order is not appealable. So how is it that this order is appealable? It seems to me that an order on a motion to vacate under Rule 9180B2 is an order on a motion that suspends rendition, and therefore it is not appealable under 9130 sub 4.
Your Honor, I like that reasoning, because under your reasoning, this motion was timely filed, and therefore it suspended rendition. And once it did, in fact, suspend rendition, then we should be here on that original appeal.
You think that means only a motion that successfully suspends rendition?
Well, if it were not timely filed, would it suspend rendition? If that motion had been late,
I think if somebody files a motion for rehearing in a civil case 45 days late, you can't appeal the denial of that on the ground that, well, after all, it didn't suspend rendition, it was late.
because
I
you,
think they mean a motion that, if timely, suspends. The motion is of the kind of motion that suspends rendition. It is not appealable. Pretty sure that's what that means.
okay, well,
So how is it that this is an appealable order?
it's an appealable order because it's a final order in a workers' compensation case, and because in fact, as I've said earlier, because the motion was timely, if the 5 additional days after service were added, and also if the rule is looked at as,
But if you're right,
yes,
if you're right, we are then going to have to reverse this case, and the opinion would then be sort of the poster boy for the workaround of this 10 days. Wouldn't anybody who messes up on the 10 days could say, oh, don't worry about that. We've got Bowe versus McDonald's. The 10 days doesn't mean anything. You can just call it an order on a motion to vacate.
respectfully no, Your Honor, because of several reasons. First, it wouldn't be an open-ended, you can file it any time you like. It would be there's an additional 5 days after service by mail. So it should have been filed within 15 days, and this one was. Secondly, you've still only got the 30 days window within which to file a notice of appeal. You've only got a 30-day window before an order becomes final by operation of statute. So there's not some opening of a can of worms, if that's what Your Honor is concerned about.
By your argument then, and correct me if I have it wrong, the 10 days means nothing. It really means 30 days. You have 30 days to file a motion to vacate, because that is the time within which to appeal.
Respectfully, Your Honor, that's what this court said in Puckett Oil. If I may just give you one quick quote from Puckett Oil, and then I'll sit down as I see I'm into my rebuttal time. In Puckett Oil, this court said, if a provision, though mandatory in terms, is designed simply to further the orderly conduct of business, such provision is generally deemed directory only. And in that case, this court held that a 20-day time limit to file a response was not mandatory, and that the judge of compensation claims abused his discretion by refusing to consider a late filed response. And it's our position that that's exactly what has happened here. Thank you.
May it please the court. My name is Clay Meek. I'm here on behalf of the appellees. And I would just like to begin my discussion here today by outlining the factual procedure of what happened at the trial court below. A hearing was held on January 26 of 2005. The order was issued on February 10 of 2005. On February 14 of 2005, the appellant's attorney received that order. On February 23 of 2005, the appellant's attorney discovered that he had received that order. On February 24, 2005, one day after the appellant's attorney was aware of that order, the motion that we are here today on was filed. Thereafter, that motion was denied, and we find ourselves here today. I would submit that as the questioning has gone here today, the rule of appellate procedure and the rule of workers' compensation adjudication is very clear, that if an abbreviated order is entered, you have 10 days to request that that order be vacated and that a full order with findings of fact and conclusions of law be entered. You do not have to make that a verified motion. You do not have to set forth legal authority. It quite simply can be a one-sentence request with a certificate of service on the back of it sent to the judge. The party hereby requests that the abbreviated final order be vacated and a full order with findings of fact and conclusions of law be entered.
Well, do I understand you correctly to say then that the 10-day time limitation in the rule is a jurisdictional bar?
It is jurisdictional.
Which affects one's appeal. And if one does not file the motion to vacate within the 10-day period of time, then the party is, despite the fact that a notice of appeal is filed within 30 days from the entry of the abbreviated order, the appeal is nonetheless foreclosed.
That is correct, Your Honor.
So it's jurisdictional.
In that sense, it is just the same as if the 30-day time limit for a normal appeal is jurisdictional.
Now, when Rule 9.182 was adopted by the Florida Supreme Court, it either simultaneously or it had adopted Florida Rule Workers' Compensation 4.115C1 that had formally allowed a JCC to vacate or amend an order, an abbreviated order, within the 30-day time limitation period as provided in Section 440.25(5)A Florida statutes. Are you familiar with that?
Yes, sir, I'm familiar with those rules.
All right. Now, so when the Florida Supreme Court referred in Rule 9.80B2 that unless a request for findings of fact and conclusions of law is timely filed, it's clear that the time that rule was adopted, it was talking about the 30-day time limitation period, otherwise provided in Florida Compensation Rule 4.115C1.
No, sir, I don't believe so.
You did not?
No. I believe that if you look at the history of when that rule was enacted, the specific appellate rule that adopts the 10-day time limit was enacted after the Supreme Court had pronounced that the formal...
Yes, but that didn't occur until 2004. This is the amendments of Rule of Workers' Compensation Procedure. The Florida Supreme Court repealed all its own rules, and the Department of Administration then was given authority to adopt rules of procedure in trial proceedings. It was subsequent to that time that the rule in question was adopted, that is, Rule 60Q 6.119, dealing with the 10-day limitation rule.
No, sir, I do not believe
all right,
that.
tell me when that, the date of the adoption of that.
What
authority did DOH have to adopt any rules prior to the repeal by the Florida Supreme Court?
As the Florida Supreme Court stated, when it did repeal the prior rules, that authority had existed within the Office of Judge of Compensation Claims and the Division of Administrative Hearings pursuant to 440.45.
Notwithstanding the Florida Rule of Workers' Comp, which permitted a JCC to vacate or amend an order within the 30-day time limitation, which was simply a codification of this court's case law?
Yes, sir. The Supreme Court, in essence, stated that that procedural rule, the old 4-point rules, were improperly applied once DOA and the Offices of Judge of Compensation Claims enacted their procedural rules, which they were specifically entitled to do by the legislature.
They didn't adopt until the Supreme Court specifically stated it no longer had the authority to adopt rules of practice and procedure.
No, sir. I don't believe that's correct.
All right. When did the Supreme Court say that prior to amendments of rules of workers' compensation procedure, which is found at 891 Southern 2nd, 474, when did it previously say it lacked the authority to adopt rules of practice and procedure?
The court did not previously state that it lacked that authority. However, the issue came before the court at that time because DOA had enacted the rules which they were entitled to enact by that Supreme Court's pronouncement. The issue came before them that way.
The Supreme Court did not pronounce that until 2004, and you say that notwithstanding the Supreme Court's assumed authority to adopt rules, that Bowe was nonetheless adopting rules contrary to those of the Florida Supreme Court?
Yes, sir. That's how the issue presented itself to the Supreme Court to make the pronouncement.
All right, tell me what was Bowe's authority then in that regard?
440.45, Your Honor, allows the judges of compensation claims in the Division of Administrative Hearing to enact procedural rules to govern the cases that go before them.
Speaking of Chapter 440, counsel, if I may, 440.255A states that the legislature accords the authority to the Florida Supreme Court to adopt the appropriate rules of appellate procedure. But then the next sentence states that final orders of a judge of compensation claim are not valid until, or are not final, until mailed within 30 days. In other words, the order is not final for 30 days. And then it says, unless appealed under the aforesaid rules, essentially. Can you tell me how you interpret that as it applies here, in that an abbreviated order is entered and a party does not move for 10 days for a final order, or factual findings? Does that not shrink the effect of that abbreviated order to 10 days in contradiction of 442.5?
No, sir. The abbreviated order still does not become final until 30 days have expired. There is nothing regarding the rule that regulates when a request for a full final order can be made that changes that in any way, shape, or form.
Okay, let me see if, excuse me for interrupting, but if I can follow you then. You're suggesting that the abbreviated order is not final for 30 days.
That is correct.
Therefore, in this case, could counsel simply have had appealed the abbreviated order within that 30-day period?
No, sir. When an order becomes final and the time within which a party has the right to appeal that order are two separate and distinct things. The finality of a workers' compensation order is germane to 440.24, which deals with enforcement of workers' compensation orders. As an administrative judge, the judge of compensation claims has no authority to impose his order on the parties. He may only pronounce it. A party, if they seek enforcement that a party does not voluntarily give, must go to circuit court and must present to circuit court under 440.24 with a final order that has become final after 30 days. Once the order becomes final, you have 10 days within which to go to circuit court.
Doesn't Section 440.25(5)(a) establish the time limitations for appeal of a final order, which is in fact 30 days?
Yes, sir.
All right. If that's the case, then doesn't that lend some strength to appellant's argument that they nevertheless had 30 days in which to appeal this order?
No, sir. Not when the applicable rule of appellate procedure coupled with the DOA rule of procedure regarding requesting a full finding of fact.
All right. What we're dealing with here, it seems to me, unfortunately, are two separate rules. You're dealing with a Florida rule of appellate procedure, talking about saying, in essence, unless a request for findings of fact and conclusion of law is timely filed, review of the abbreviated final order shall be deemed waived. And then you've got, which is still on the books, and then you've got the DOA order saying nothing about the appeal time, but simply specifying the time for making a request to vacate an abbreviated final order. It should be done. It doesn't say shall. It says it indicates that it should or may, which seems to suggest that it is directory or perhaps even discretionary.
I would submit, Your Honor, that the hypothetical that Justice Padovano suggested is the more appropriate way to interpret that, which is that if a party wishes to challenge an abbreviated final order, they may do so if they do it timely within the 10 days.
But, counsel, doesn't that mean then these two procedural rules conflict with the statute that says an order is not final until it's mailed 30 days after its rendition?
No, sir. When an order becomes final, and when an order may be appealed are two separate and distinct things.
Tell me, what authority does DOA have to shorten the amount of time specified in the statute for an appeal of a final order, i.e. 30 days? Where is that statutory authority?
They are allowed to enact procedural rules pursuant to 440.45, Your Honor, which is what they have done.
However, I think the rule is clear that an agency only has such power that is either expressly or implicitly delegated to it by statute. Where is the statute? In other words, a general rule-making authority doesn't either expressly or implicitly confer upon DOA the power to shorten the appeal time.
In effect, the rule does not, Your Honor. All that the rule requires is that you request a full order of findings of fact and conclusions of law within 10 days. Once that new order is entered, you then have the 30 days within which...
But doesn't that make the abbreviated order final within 10 days and not within 30?
It makes that order final only, well, it makes it non-appealable only if you don't act on it within 10 days. That abbreviated final order is still not final until the 30 days have been expired.
But the 20 days difference between the 10 days you should have filed a motion for full findings of fact and the date you say it becomes final is sort of a twilight zone, isn't it? I mean, in other words, you can't appeal after 10 days. You are locked in to that abbreviated final order, and yet the statute says the abbreviated final order is not final for 30 days. What's the purpose of that additional 20 days?
The purpose of the additional 20 days, Your Honor, would be that if a person does timely make that request for a full finding of fact and conclusion of law, the court then has the time within which to do that and allow the parties to proceed.
Does this rule shorten the time to appeal, or does it provide a circumstance in which a party simply waives the right to appeal altogether?
Between those two options, it would be more that it provides a circumstance that a party waives the right to appeal. Because if you timely make your request for a full finding of fact and conclusion of law, that is granted by the JCC. There is no question within the rule that the JCC must do that. Upon entry of the new order, you would then have the 30 days.
So assuming then that it takes 5 days for the abbreviated final order to reach counsel, just based on the general assumption of the 5-day mailing period, applicable in other situations, and I'm not suggesting necessarily that appellant's position is well taken on the 5-day argument, but counsel receives the abbreviated final order 5 days after it's been rendered. They now have 5 days only to seek a full finding or a detailed order complete with factual findings, or they're completely locked out of challenging the abbreviated final order, right? Under your argument.
Under the rule and under the appellate rule, yes, Your Honor. And in this case, specifically demonstrates that that is not an unreasonably short amount of time. Because as demonstrated by this case, when the appellant's attorney discovered that motion or that order sitting in his office, he filed his motion to vacate it 1 day later. And it was a full motion.
Tell me something. What would be the problem with interpreting Rule 9.80b2, wherein it states, unless a request for findings of fact and conclusions of law is timely filed, to mean the terms timely filed is simply limited by the 30-day period of time provided in the statute, rather than in the rule adopted by DOA?
It would make the rest of that, I apologize, I see my time has expired. May I answer the question? Thank you. It would make the rest of that rule surplusage. There would be no need for the rest of the wording of that rule.
Well, if review of an appeal of an abbreviated final order should be deemed waived, i.e., if you don't file within your 30-day period of time, it's waived, which is consistent with the rule anyway.
But if you allow that full 30 days, Your Honor, and said that that is all the appellant or the aggrieved party needed to do, what this court would end up with is multiple abbreviated final orders.
And isn't that really consistent with what the Florida Supreme Court said when it adopted Workers' Comp Rule 4.115C1, which permitted the JCC the authority to vacate an amended order within 30 days from the rendition of an abbreviated final order?
I believe the more correct pronouncement of the Supreme Court's position on this is the Millinger case, Your Honor, wherein they specifically stated that excusable neglect, such as urged upon this court.
We don't know. No one has reached the issue of excusable neglect. We're simply here in a which appears something. I mean, if we accept the JCC's order in face value, he's saying, in essence, this is a jurisdictional time bar. He has no authority to rule on it without any consideration of excusable neglect.
What Your Honor is to do otherwise is to, in essence, force this court to review abbreviated final orders with no findings of fact and no conclusions of law, which would necessarily mean that a party could ignore the 10-day requirement of the Doe rule, ignore the 10-day requirement under the appellate rule, and simply proceed to this court with an abbreviated final order and say, you have nothing to review, you must remand it back down to the judge of compensation claims to enter a new order and give me another bite at the apple when I've sat on my hands.
Okay, thank you very much.
Thank you.
Counsel, could I ask you to address your opposing counsel's last statement, that if we rule in your favor, that essentially we'll be creating precedent here by which, as occurred here, an abbreviated final order that is not challenged within the 10-day rule will simply be appealed to this court, and this exact scenario is going to recur more than once, may I suggest?
Respectfully, Your Honor, that would not occur because, as Judge Irvin has suggested, if there's a 30-day window of time and the appellate rule that speaks to a deemed waiver applies to the 30-day window of time that's provided in the statute, Section 440.25.
But what does the statute have to do with the time? All the jurisdictional time limits for taking an appeal are procedural events that are described in the rules of appellate procedure. 15 days for the state to appeal an order in a criminal case, 30 for a civil litigant in a civil case, 30 for the defendant in a civil case. Every single one of these time periods is a rule of appellate procedure. It's not a statutory thing. So why doesn't the Supreme Court have the authority to tell us you have 10 days to preserve your right to review an abbreviated final order? Isn't that a procedural matter for the Supreme Court? You want me to tell them they can't do that?
The Supreme Court can, in fact, set time limits for filing a notice of appeal. What's happened here, though, is that the Division of Administrative Hearings has adopted what the appellee urges is a jurisdiction.
Hearings established the 10-day filing period.
Exactly. It was the Division of Administrative Hearings that adopted that 10-day limit. And if, in fact, that's a jurisdictional limit, as the appellee suggests, then that's an unconstitutional.
Did the Supreme Court essentially adopt that in 9180B2 when it says timely filed motion?
Well, that rule doesn't define.
The only rule that governs the time is the JCC rule.
The JCC rule. May I have leave to answer your question and conclude, Your Honor? The rule that governs that time, that 10-day rule, was actually not the rule when that Florida Supreme Court deemed waiver provision, the appellate rule, was published for comment, and comment was accepted and was argued before the court. When that was adopted, there was a 30-day statute in effect. The Florida Supreme Court can change it, Your Honor, but respectfully, the Division of Administrative Hearing does not have the power to shorten our jurisdictional time for filing a notice of appeal, and yet that is exactly what appellees suggest that they have done. May I have leave then, just to conclude? The appellant would respectfully request then, Your Honors, that you reverse the JCC's denial of the motion to vacate and the entry of a full order, and reverse the finding of the 30% apportionment.
Okay. Thank you very much. We are adjourned.